Welcome to another episode of I'll Allow It Nevada, your reliable source for quick insights into Nevada's judicial education. I'm your host, Anne-Marie Mayu.
And I am your co-host, Seth Beasley.
And we proudly represent the Supreme Court of Nevada, Administrative Office of the Court's Judicial Branch Training Unit. In this episode, we're focusing on the foundational topic of judicial ethics. And we are honored to welcome our guest, Supreme Court of Nevada Justice Linda Bell, and from Department 9 at the 2nd Judicial District Court, Judge Scott Freeman. It's a pleasure to have you both here.
Thank you for having us.
Thank you. So we're going to start our first question off, and we are just going to throw this out here. Could you start by giving our audience a brief overview of what judicial ethics entail and why they are important in maintaining public trust in the judiciary?
Judicial ethics are the rules by which judges maintain themselves, and that is everything for the respect that is given to the judiciary. I love this particular statement from the preamble to the model rules. Judges should maintain the dignity of judicial office at all times and avoid both impropriety and the appearance of impropriety in their professional and personal lives. They should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. Public trust in the judiciary relies on having judges who people believe are fair in following the rules.
You know, there's another piece that might be a little more conceptually appropriate, which is that judges are a separate branch of government, and the public wants to believe that we have something or someone to answer to, that we're not out there as cowboys. And the reality of it is that judges are elected or appointed, and they were previously lawyers. And it's a different way of looking at things when you become a judge, because you need to make sure that the public knows that we can be trusted when we make decisions that affect everybody's life. And that's what the ethics provide for us, as a framework for that.
And those are such big decisions as a judge and a justice that you have to make. Is there someone that you answer to?
Well, you answer to the voters every 6 years. And depending on where your election is, it depends on, again, the circumstances of your reputation and the work that you've done. And for example, in Clark County, there's over 60 judges that do what I do. In Washoe County, there's 9. So it's quite a different microscope and magnifying glass, depending on where you are a judge. But the ethics apply to us all as judges. And so we have to have the insights to make the right decisions. And the most interesting thing that we'll get into in our show today is that some judges don't think that way. And that's how the decisions are made that give other judges guidance of, I can't believe Judge so-and-so did this, because they weren't thinking about ethics and canons, and they're human and making decisions that some of us are surprised at. And that's what makes the law of judicial ethics.
Right. And that piece of judges are human, I think the general public sometimes forget. They forget.
Sometimes judges forget too.
Sure.
What is the Nevada Code of Judicial Conduct, and how does it guide the behavior of judges in Nevada?
So the revised Code of Judicial Conduct is the rule book that sets out the ethical standards for judges. It is mostly based on the American Bar Association's Model Code of Judicial Conduct, although we have some notable exceptions. And it is a set of canons that are large guiding principles for how judges should act, with specific rules, and then comments that help give guidance to judges on more specific topics. So it goes from the broad canons to general rules to very specific comments.
Maybe I could give an example that might be interesting. You know, as I previously alluded to, judges are former lawyers at the district court and Supreme Court level, Court of Appeals level. And as lawyers, we're called all the time to give legal advice, right? That's what we do. People call us, make appointments. They want legal advice from us. There's a canon on point that says it's against the law. I always say against the law. It should be against the canons. But the way I look at it as a district court judge, it's against the law for me to give legal advice. And you'd say, well, why is that? Well, think about that for a moment. A client that I used to represent gives me a call and says, can you tell me what to do? I don't pay attention to that particular canon that I just alluded to. And I say, you can do this, this, and this. Well, the first thing that client's going to do is say, Judge Freeman said in the court he or she is in, that I can do this, this, and this. Of course, that's impermissible because they're not going to be before me. They're going to be before another judge asking for that legal advice from me. In addition, you can't give legal advice because under the circumstances, it could be wrong. And they could say, Judge Freeman said this or said that. And that's a very interesting piece because when you make the transition from lawyer to judge, one of the cans are it's illegal to give legal advice.
I think one of the challenges in ethics for judges is that it's not all intuitive, and things that were completely acceptable or even encouraged of lawyers are things that you can no longer do as a judge. For example, fundraising for a charity. When I was a lawyer, I sat on boards. I did all kinds of charitable fundraising. We're not allowed to do that as judges. I mean, it even becomes complicated. I remember when my daughter was a Girl Scout, selling Girl Scout cookies and how to manage that. I bought a lot of Girl Scout cookies.
Well, your point's so well taken, Justice. It's because, and it makes sense if you stop and think about it, because as I was on charitable community service committees as well as a lawyer, it's different now. Hello, this is Justice Bell. I'd like you to buy some Girl Scout cookies. Oh my goodness. Number one, says the customer, I've got Justice Bell on the phone. Number two, Justice Bell wants me to buy Girl Scout cookies. Number three, how many cases do you want me to buy, Justice Bell? I may be in front of you. My business may be in front of you. My friends may be in front of you. That's called a conflict of interest. And that's exactly why we cannot participate in any type of charitable event. But it also says, hey, maybe somebody might sue the Girl Scouts. And all of a sudden, you're a proponent of the Girl Scout cookies. And I'm going to say, hey, Justice Bell wanted me to buy cases of Girl Scout cookies. Now the case is before her on the Supreme Court. It is fraught with problems.
Now, the really important point to make here, though, is can you buy Girl Scout cookies still?
Of course.
Absolutely.
I'm
and eat them. Buy and eat them.
And eat them, good.
Of course. You can't tell anybody that you're behind it, but we enjoy Girl Scout cookies very much.
Everyone does.
But I can't endorse them, by the way. Cannot endorse Girl Scout cookies as a judge. Right. I can just tell you that I like to eat them.
Okay. Mm-hmm. Okay. And many other cookies, right? cover the bases.
Well,
all brands.
Now that you mention it.
All brands of cookies.
Yeah, that's really interesting that ethics for a judge are not intuitive and that there is that big difference between what a practicing lawyer has to consider when they're considering ethics. That's really interesting. So you kind of mentioned a couple rules already. Are there any other principles or rules within the Code of Conduct that you would like to highlight?
I'd probably like to highlight the whole thing. It's all really important. I think where most judges who are trying hard run into concerns are the issues of conflicts of interest, because those happen every day almost. There's some issue of, am I too close to this? Do I need to disclose this information? We live in the communities we serve, and so we may know people involved, or we may know, we may have family members that work for a business, or my sister worked for a large company that owned several casinos, and she did finance work. Every time I had a slip and fall case with one of their properties, though, I had to disclose that. I didn't think it impacted how I would hear the case, but I had to be mindful of that, because if somebody came back later and said, well, the judge's sister works for this company, they could have concerns about whether they were treated fairly. And so I think conflicts of interest is a really big area. Community involvement and fundraising, which we already talked about a little bit, are big. We're encouraged to be active members of our community and participate in things in the community. At the same time, it's really fraught. We have to watch out or if we're overstepping a line by, can we be on the host committee for a dinner? Can we, how far our community involvement can go?
Well, such a good point. The most important thing about those circumstances is that there are choices to be made with your career as in the legal profession. And if you decide to be a judge, it is true that you give up certain common, I'm not going to use the term common rights, but we're a separate branch of government. And so we're not political people. At the same time, we are. But you absolutely cannot have a political opinion related to being a Democrat or Republican and bring that to the bench. Democrats and Republicans expect you to be fair and impartial when you're hearing their case. You cannot endorse a candidate in your position as a judge. There's a number of different canons that are absolutely reflective of the transition you speak about, Seth, going from being a lawyer to being a judge and being a citizen, and then potentially working your way to be a judge. Because in our state, interestingly, we have judges that are not legally trained that are allowed to be a judge in some of our rural communities. They are also bound by the canons of judicial ethics. And so what a judge does when a case is before them is they do what I call a gut check first. Then they secondly decide whether, if there is a potential conflict like Justice Bell spoke about in her sister's situation, whether or not you have to tell anybody about it. Maybe it's so remote that you in your mind, after reviewing the judicial canon, say, I don't have to say anything. This is so clearly I don't have a conflict, I'm just going to move on. But the safest play, so to speak, and the safest thing a judge should do is what Justice Bell alluded to, which is called disclosure. And what disclosure means is that if you have to, what Justice Bell and I always would talk about together is if you have to think about it, you should disclose. And if you disclose, that means I'm Justice Bell. My sister works for the casino businesses in the finance department. Do any of the parties feel uncomfortable now that I've made the disclosure that I possibly could not be fair and impartial? I'm telling you that I can be. I've done the gut check the way Judge Freeman says it, and I can be fair and impartial. But there could be what we call an appearance of impropriety, that because of my relationship, and if you feel uncomfortable, I will recuse myself. No judge can be blamed if they do that appropriate disclosure. Sometimes a judge might say it differently. I want to make a disclosure, but I'm telling you up front, I can be fair and impartial. But you still leave it to the litigants. And sometimes they might ask that you recuse yourself, not because of the conflict, but maybe for strategy purposes. But we have so many cases that I'm happy to get off a case if I make a disclosure and I put it for myself and my ethics that I had a conflict and I get off the case because I'd made the appropriate disclosure, and the lawyers can make a decision with their clients whether I should get off after the disclosure is made.
I think that's a bit of a complicated issue in Nevada, though. I mentioned before that Nevada models itself after the ABA model rules of judicial conduct, but this is one place where Nevada is a little different. And we maintained something called the duty to sit, which was in an old version of the model code, the ABA model code, and has been eliminated in favor of judges more liberally getting off of cases when there's an appearance of impropriety, when there's some sort of conflict. But in Nevada, we have to balance out the tension of, do we have an actual conflict of bias or prejudice that would make it hard for us to be fair in the case, not just how it looks, because we also have a competing obligation to sit on cases if we believe that we can be fair. And sometimes that can be really hard to navigate.
Interesting example. I had a conversation with a brand new judge a while back who was adamant that he didn't have to give up his rights because he became a judge. And he was talking about an experience that he had at church, where a church person came to him and wanted some advice, and it was in the context of that, and he didn't want to give up his, I guess, religious freedoms to respond to the question. And I said, it's perfectly fine, but if there's a case that comes before you related to your church, you'll have to disclose and potentially recuse yourself. And if the subject matter of the person who asked you the question comes before you, you'll have to recuse yourself. Wouldn't it make more sense to follow the canons and not participate in such a conversation? and remember that you're a judge, and remember the rules that you decided to follow by becoming a judge. And that's, I think, one of our biggest challenges as judges and justices that have been on the bench for a while, is that we see those kind of choices and judges really not embracing the rules, because it's really easy. If you have to ask, it probably is a conflict, because you identify that most things that we do in life could be a conflict of interest. Harmless, significant, insignificant, don't worry about it, it's irrelevant. But that's the analysis you have to do when you decide to be a judge. If you don't want to do that, don't be a judge.
While we pause for a quick break, I'd like to extend a special invitation to our listeners. I'll Allow in Nevada goes beyond just being a certified legal education podcast. It's crafted with inclusivity in mind, welcoming all who are interested. Our goal is to foster connections with communities and offer valuable insights into the Nevada judiciary. If you found our episodes engaging, we encourage you to spread the word and share this experience with your friends and family. Your support is greatly appreciated.
And to know that you would say, okay, this is the situation. How do you feel about that? You know, to say, this is what I'm involved in as far as your case is concerned. And you put it back in the lap of the litigants and you say, how are you feeling about that? I think that is just very respectful.
Well, it's also the rule.
Right.
And may I give another example? Yeah. So there's very limited amount of community service we're allowed to do. One of the community service pieces that the judges can do in Washoe County is the Reno Rodeo. In fact, former Chief Justice Paragary is on the foundation committee. Former district court judge, God rest his soul, Pat Flanagan, was on the security committee. And Mike Montero was also in charge of the rodeo arena for many years as a sitting judge. So there's been precedent that judges are allowed to participate in the rodeo because it's a community event, as long as we're not involved in the sponsorship aspect of it or the request for money or charitable money. And so I participate in the rodeo, and I followed the lead of Judge Flanagan, and I'm on the security committee. A couple of years ago, while I was on the security committee, I was aware of someone who had committed a criminal offense at the rodeo. Heard about it amongst my security world, and lo and behold, it ended up in front of me as a district court judge.
Oh, wow.
Very interesting. So immediately I did the analysis. Could I be fair and impartial? Yes, I could. Didn't know the individual, wasn't completely aware of the facts. It was fresh and new to me from a gut check. Then I moved to, should I disclose it? Well, of course. The rodeo's the victim. I volunteer at the rodeo. Should I sit? And what I did is I made it at what we call a full disclosure. I'm on the security committee, told the lawyers I'd heard something about the case, wasn't sure about all the facts. I felt that I could be fair and impartial, but I'll leave it to you whether you want me to stay based upon my connections with the Reno Rodeo, and they were a victim. They decided to keep me on the case. I rendered a fair decision as what should happen to the offender, and interestingly, approximately 2 months later, we received an email to my chambers by a member of the public who said, Judge Freeman, I understand that you are on the security committee at the rodeo. It's well known. It's a public forum that I participate to give back to the community as part of my role as a community member and judge. How were you able to hear the so-and-so case if you already knew about it? Well, fortunately, I'd made a complete disclosure. The lawyers had agreed that I stay on the case. Candidly, I simply responded by saying, please review the transcript. Because the court reporter, of course, takes everything down, and I made a full disclosure and the lawyers consented. So it was a great example of, man, I did that correctly. And I got called on it. So it's very, very helpful to have done that. So that's my example.
That's awesome. It's kind of just that thought of just not giving anyone anywhere to go with it. I've checked all the boxes.
But you got to know the rules to be able to check the boxes.
So as a new judge, gosh, those canons need to be by your bedside, right? And you need to know them.
There's a whole bunch of resources, not just the canon. Absolutely the best place to start is just reading through the Code of Judicial Conduct and understanding what the rules are. The Nevada Discipline Commission has a website. The rules are on their website. They also have disciplinary decisions, which can be pretty informative, learning from other people's mistakes. And then there's advisory opinions, which is a great resource. An individual judge can send in a question and get an advisory opinion. Doesn't work if you have something you need right this second, but it's good for some of these broader issues like, can I do security at the rodeo? They can handle those kinds of broader topics, and they have a whole body of opinions, advisory opinions, and it's organized by topic. And so you can go in and look and see, is this okay? Is this not okay? And then, more broadly, there are people who write on judicial ethics. There's law review articles on judicial ethics. There's all kinds of resources outside of just our state on some of these topics that are a little more complex.
Well, it is a complex topic for sure. So I'm curious, how do judges ensure their impartiality when making decisions? You talked about the gut, which I think is very important just in general in life. But do you have some specific ways that judges can navigate that challenge of maintaining that impartiality?
Well, my answer to that is 99.9% of the cases that are before me, I know nothing about until they get there. If, in fact, I know something about the case before it gets to me, that's the first test. How do I know it? Why do I know it? Did I hear in the news? Did somebody close to the case talk to me about it? And so I like to think that when we talk about impartiality, we take seriously our canons, despite what our personal beliefs are, which is always the challenge for new judges. We have to maintain the fact that if you were in front of the judge, says new judge, would I want a fair shot from you? And how do I accomplish that? By setting aside, by compartmentalizing in a very strong way, as you did when you were a lawyer. You put things aside. When you represented somebody who you didn't believe that is something you would do, but you represented them anyway because that's your job as a lawyer. You do the same thing as a judge. You need to set it aside and know that you can be fair. And if you can't, it goes back to the gut, get off the case. And if you heard something about the case, disclose. And if all of those tests are met, that can assure the public of impartiality.
One of the judicial education trends of the last maybe 10 years is implicit bias, and really getting to understand maybe some of the ways that we have biases that we are not consciously aware of. I think that's incredibly important for judges to try to recognize any place where they may be making a decision based on something other than just the facts that are in front of them. So I think that judicial education piece is really important. And I absolutely agree with Judge Freeman. There's a mental exercise that you have to do as a judge where you say, okay, I have this potential concern or this potential personal thought about this, and I'm going to put that over here so that I can follow the law and make a fair decision. When I was on the trial court, I don't think a week went by where I wasn't making a decision based on some law that I personally would never have written or never have written in that particular way. But that's the job, right? It's not about what I believe personally. It's about carrying out the law and coming to the best decision possible given the rules that exist.
One of the things that's so important by way of what Justice Bell just said is that when you become a judge, you have such an awesome responsibility that it's just simply not fair not to be fair. Because as Justice Bell said, she may not personally agree with a particular law, but the lawyers and the litigants are expecting her to follow the law. And it's such a broad and important responsibility to follow the law is what we do. We don't make law, the legislature does. That's the legislative branch. We're the ones that follow the law. And so they need to have the confidence that we're going to follow the law. And I would never want to know, nor would I want Justice Bell, then trial Judge Bell, let me know why she didn't like the law that I was asserting was the right thing to be successful for my client. I'm hoping that Judge Bell would follow the law as I can depend on it. And any other result would be unfair, in my view.
Right. I think that's the very, very powerful statement that it isn't fair not to be fair. Yes, that's very true.
I think one really important area of conflicts, and one of the things that's most difficult for judges on a day-to-day basis is navigating personal relationships. And it's a place where our rules fall a little bit flat. They don't provide us guidance. I think they're very dated. They don't provide for things like judges dating or having former spouses. So the American Bar Association did Formal Opinion 488, and it is a beautiful opinion that sets out categories of relationships and how to navigate those. When you need to disclose, when you need to recuse, and when you don't really need to do anything. Like say a judge is in a professional organization with someone else, and that's really the extent of the relationship. There probably doesn't even need to be a disclosure. And the formal opinion goes through the analysis and with some really specific examples of how to manage those relationships and when to disclose, when to recuse.
And that's just a regular, everyday life situation. Because again, our judges and justices are human. You're going to have relationships, and you need to have those rules of how to navigate that and what is appropriate.
Even in a community as large as Clark County, I had so many times where I'd discover I knew somebody. I was in the middle of a bench trial and a witness came in. And when the witness walked through the door, I realized it was somebody that I knew through a professional organization and is my neighbor. And he has a very common name, so it just never crossed my mind. And so then we had to stop the trial. I had to make a disclosure. We had to decide how we were going to proceed. And the trial did just proceed at that point. But those things come up on a daily basis. And for the judges that work in smaller communities, it's even tougher because everybody knows everybody.
I think the most telling rule of thumb for judges that may be hearing this podcast is if you have to ask, you need to disclose. And I'll tell you why. I had a situation. I called Justice Bell, my ethics expert. And the first thing she said to me is, did you really have to call me and ask? Just disclose. And I said, good point. That's a great rule of thumb.
I don't think that's quite how I said it.
Well, that's why the two of you are sitting here and reviewing all of the judicial ethics, because I know I've heard several of your sessions on it, and every time I learn so much, and I know all of our judges do. So thank you.
It is very valuable to have a sounding board, though, when those ethical considerations arise. And I certainly have called Judge Freeman on more than one occasion also to ask him questions about how to navigate a difficult situation, because some of the problems you just don't really, they're very unexpected and they come out of nowhere. And it surprised me as a newer judge that the ethical problems that we face are daily.
A heartfelt appreciation to our guests and to everyone who has tuned into this podcast. Before we wrap up, here are a couple of important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. And if you have any questions, topic suggestions, or comments, we welcome your input. Please email them to jepodcast@nvcourts.nv.gov. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada, released every first and third Friday of the month. This is Seth Easley signing off. Take care, Nevada.